Imagine, if you will, your messy tenant who is behind on rent just sent you a maintenance request reporting a mouse on the property. You think to yourself, there's never been any other complaints about rodents or other pests. The other tenants who are current on rent aren't complaining. If there are any pests on the property, it's probably because of the way they keep their apartment. Your gut is telling you not to do anything except ignore their request. Well, you better think twice. I'll explain. So, who's responsible? In the state of California, pest control is primarily the landlord's responsibility. This falls under the implied warranty of habitability, where the landlord has the duty to maintain residential rental units in habitable condition for the entirety of the lease agreement. In fact, rodents and vermin are specifically named. The California Department of Justice states in a consumer alert that your landlord must provide adequate pest control for rodents, like rats, and insects, like roaches and bed bugs. Is the tenant ever responsible? Yes, the tenant does have some responsibilities. California Civil Code 1941.2, also known as the tenant's duty of habitability, states that tenants are required to keep their units clean and sanitary. However, if you're in front of the judge trying to make the case that the pest problems are due to the tenants not keeping their duty of habitability, you will want to show that you made every effort to do your part. What if pest control is named in the lease agreement? There are some pest control costs that can be allocated to the tenant if included in the lease agreement in certain specific situations with single-family houses. You just want to be careful and resist the temptation to get too creative. There's no clever trick or phrase you can put in a lease that will get you around your legal obligation as a housing provider. However, if you're leasing a single-family house, you may be able to have the tenant pay for periodic pest treatments, but you have to be careful. The car lease agreement, updated 1223, has a provision giving the option where either the housing provider or the tenant shall pay for periodic pest control, depending on the box you check. If no box is checked, then no periodic pest control is promised, but all duties of habitability still remain for both the tenant and landlord. Please note that the car lease agreement specifically states this obligation shall only be applicable if the premises is a house and the periodic pest control treatment is being provided at the execution of this agreement. It then asks the housing provider to state the current cost of treatments being provided. Even if you choose to pass on that expense to your tenant, you will still have the obligation to help with additional pest control needs if there are other pest issues. You can also tell from the language in the car lease agreement that this option does not apply for multifamily properties. If you have a lease clause for a single-family house that requires the tenant to pay an outside company, this can create extra complication. You may want to consider paying it yourself and building it into the rent if pest control is an issue on your property. What if the tenant is behind in their rent? If the tenant is behind in rent, or if there's any friction going on at the property, you will want to be particularly diligent on being responsive to pest complaints while taking extra care to document your efforts. A false pest report is the oldest trick in the book, so don't be fooled. Don't forget that the presence of pests can be hard to prove or disprove, but your actions or lack thereof are easy to show. This is why you need to be diligent with your documentation. Who knows? There may be a long existing pest issue on the property, but your tenants might not report it until they want out of their lease or they can't afford their rent. Habitability complaints are a potential way to break leases, stall evictions, and even in some cases, obtain relocation assistance. This is why housing providers need to be careful and take it seriously. Bottom line, in the state of California, pest control is generally the landlord's responsibility, as they have an implied duty of habitability. The tenant also has a duty of habitability to keep the property reasonably clean and sanitary. However, the burden of proof will be on the landlord. And in today's tenant-friendly legal system, you would want to make sure you have a strong case. A housing provider may be able to pass the cost of periodic pest control to the tenant in a single-family house, provided it's done correctly. But it may make more sense for the landlord to pay for pest control where needed and have it included in the rent. Pest complaints should always be taken seriously, especially in situations where there may be other issues with the tenant. However, diligent landlords who do their part and document everything have nothing to worry about. This is not legal advice. We are not attorneys. For legal advice, you should seek the advice of an actual attorney. For legal advice regarding landlord-tenant matters, you should seek the advice from an attorney specializing in landlord-tenant law, preferably near the location of the property. Rules can vary a lot depending on local laws. For real estate advice, if you're looking for a reliable property management company or a real estate broker in Long Beach, Los Angeles, or Orange County, California, or if you're just considering it and have a few questions about real estate, contact the Mike Dunphy Group today. We are happy to help.